Okay, thanks, Mary. And thank you, Mary, for setting this up again, another exciting program. And we appreciate all that you do to make these happen, and especially with the Zoom situation and everything. It's always been pretty flawless. So thanks for all your work. I want to sort of tee up the topic, if I could just briefly, and then turn it over to our panelists. I had a case at one point where I was working with Jerome, and I think we got a draft back of the report and realized that we had the gender wrong of the child in the report. And when we had to revise the report, it was really shocking what happened to the numbers, the downward trajectory that they went on when we went from a male child to a female child. And it really sort of, I remember it struck me. We'll probably talk a little bit more about that as we work through the program today. And then Bill Lightfoot approached me at the AAJ convention in San Diego, I guess a little over a year ago, and he had just heard a presentation by Robert Johnson, one of our panelists today, about the issue of race and gender and economic loss forensic reports. And we talked about it in the lobby at the hotel, a little bit about how California was on the forefront of passing legislation that would prevent the use of race and gender in these reports, and that we should talk about doing something in DC. And then fast forward, Jerome and I had another conversation about it, and it was one of those things where everybody's, I think, is on the same page and recognizes the unfairness and really the effect of systematic racism and discrimination that we've seen historically in this country, and what it does when you use historical data to build future reports out. But as you sit down and start talking about how to make an unfair situation more fair and just, sometimes the devil is in the details, and you have to put in a little more thought and consideration to exactly what it is that you're trying to accomplish. DC TLA, we are proud to be sponsoring legislation and supporting legislation at the City Council that we think will correct this historical wrong. But again, it's a little more complicated sometimes than you think. And so here we are with this great panel today. And I appreciate everybody's participation: Jerome Page, Richard Lockley, Robert Johnson from California, Subo Martha, who's on as well. And Jerome, I think I'm going to let you take it away and get things started.
Okay, thank you. So Mary, if you can help, if you can allow me to, if you can share this, give me my rights to share my screen, I'd appreciate it.
You should be able to share.
Okay, all right.
Go for it.
Okay, so is the screen share there?
It is.
Okay.
Yep.
All right. So here we are. So thanks again, Chris, for the introduction, and Mary and the DC Trial Lawyers Association for allowing us the opportunity to share our thinking. And when I mean our thinking, it's thinking by economists and financial experts on how we can go about implementing the California legislation, SB 41, or the proposed bill in DC. And so the way the webinar is going to unfold is I will present on behalf of Jerome Page and Associates, which will be a combined presentation with me, Richard, and Subodh. And after we finish, then Bob Johnson will talk about his experience in California and across the country in addressing this issue. Then Chris will come back and share his comments on our discussions and presentations. And then we'll open it up for question and answer. Okay. So I've also put a link to the presentation in the chat box. So if you go into the chat box, you can click on the link and you should be able to download the presentation from Dropbox if you want to follow along. So the topic for us at Jerome Page and Associates is the title is Race, Gender, and Ethnicity in the Evaluation of Impaired Earnings Capacity. And we'll talk about what we mean by impaired earnings capacity as our presentation unfolds. So who are we? I'm Jerome Page. I hold a doctorate in economics. Richard Lockley is an MBA. He also does forensic economic analysis. And Subodh is a PhD in economics. I'll be introducing the topic and reviewing the legislation. Richard will talk about results based on current practice, and Subodh will present some criterion option for future directions, and I'll come back with a summary. Why are we here? As Chris indicated, we're discussing a significant social issue, and that issue is discrimination based on race and gender. Now, Chris talked about it from his perspective as a lawyer. As we have seen since the murder of George Floyd, the whole issue of racial inequities, as we've seen with the COVID-19 and the disparate effects that have had on the African-American community, that there are indeed differences in American society, in the economy. And those differences get baked into statistical numbers. So consequently, what can happen is that those social inequities, whether they're based on race, gender, or ethnicity, can often turn around penalizing individuals when we go about conducting economic damages. Many of you are may be involved in genealogy projects, and one of my oldest sisters is a genealogist, and we've put together an account, and it's on my website. I can drop you the link on how our family has experienced discrimination. When they were having the political gatherings in Tulsa, they talked about the Greenwood community in Tulsa being destroyed back in 1921. It was the most prominent and economically viable Black community in the United States at that time. And it was systematically destroyed. It was bombed, in fact. It was the first bombing of a community in the United States. I mean, bombing, literally airplanes filled with dynamite, and the dynamite was dropped on the Black community. While not as violent around the same time in Bluefield, West Virginia, the my maternal grandparents, their parents had a thriving Black community, churches, businesses, recreational facilities. So much so it was the envy of the white community. Instead of being bombed, what happened was the community was destroyed through eminent domain, taking over the land for the railroads, to expand the railroads. And today, as of today, the railroads still haven't been expanded. So this issue of systemic bias, historical racism is something that is part of my family as well. And every time I work on a report and I see it, I cringe. So we're going to be talking about the proposed law in DC. And then the big question is, as Chris suggested, is it workable? And we are proposing the answer is yes, it is workable. And we'll provide you with some assessments of how economists go about approaching the question. So the legislation in DC is called the Stromiah-Dennison-Jackson Race and Gender Economic Damages Temporary Amendment Act of 2020. And this bill changes the way economists may calculate economic damages when considering race, gender, and ethnicity. And I've italicized the word may because there are some wording differences between the DC bill and the California bill. And I'll save the discussion of the California bill for Bob. But where the California bill prohibits certain things and the language in the DC bill may not be reduced. So the lawyers will have to figure that out and talk about the interpretation of the language. Another difference between the DC law and the California law is the California law has a background. It grounds its law in the concept of equal protection and due process. They see equal protection and due process as being the foundations of democracy. The preamble or the introduction to the law also says that California has been a pioneer in expanding civil rights. And they've also found that a bias exists in the methods used to calculate damages. And I would add here that the language they use in the legislation, they took the language directly from a report that Robert Johnson developed. So verbatim, they just cut and pasted Bob Johnson's findings there. So congratulations, Bob, for influencing the legislation there out in California. Another distinction the law makes is it says you can't use statistical tables alone. And so we'll be talking about what happens when you use statistical tables. In the DC, as of now, there is no written rationale. The language just says that the use of race and gender may be prohibited if it causes a reduction in economic damages. So we're focusing on impaired economic capacity. The issue covers many more areas: earnings, life expectancy, work-life expectancy. But in order to keep today's discussion pointed, we're going to focus on impaired earnings capacity. And so at that point, I'll turn it over to Richard.
Hello, everyone. What I'm going to talk about is how we get to the calculation, what the numbers are basically telling us now. What we do is the basic economic, forensic economic case is we're looking at the pre-event less the post-event earning capacities. And within that and within the data, there are race, gender, and ethnicity effects. Looking at the base level earnings, how fast those earnings grow, and the duration of losses. In the next slide, this is a basic slide that just shows the overall difference between male and female earning capacities when you look at it based on an educational level. For those looking at this chart, I mean, in blue is the male, in orange is the female. As you can see, there is a disparity within the data. The orange or kind of yellowish line, it's basically showing the percent of that difference. On this slide, just basically showing the lowest category is Hispanic women, or their earning capacity is the less. And the green line basically shows the variance between the other different categories, between Asian men, white men, all races, and so forth. And basically, when you pull that together to determine what the lifetime earning capacity is, Asian men are ranked at the highest with over $3 million. And it steadily declines from there, with at the lowest, Hispanic women at about $1.7 million. If you're using the white male bias as a comparison, Asian men earn 2% more, and it goes down further from there. Hispanic women at 64%, Black women 44%, Hispanic men 33%, Black men 28%. So there is a discrepancy as shown in the data. And how we came across this was on a case. I received a case, the name was Michael, who I just assumed it was a male, and produced our report and delivered the earnings to the attorney for the earning loss of $836,000. After I presented those earnings, the lawyer said, well, the person is a female. So I went back and redid the numbers, and it showed a $280,000 difference in the lower. The earnings dropped down to $554,000, a 33.7% difference. So that's what spurred us on to do a little more research and bring a race and gender bias. So that's it, Jerome.
Okay, suppose you there?
Hang on.
Okay. You're back, okay.
All right. You can hear me now, Jerome? Okay. Hello, everyone. I'm glad to be here. I'm quite new to this business. I have worked extensively with Jerome and Richard on energy issues. And lately, I have also begun to participate with them in forensic economics. And I'm really glad that I have this chance to be with you in this proceeding because it's a very important key issue. What Richard has shown us is that it's not just a social issue. There are huge dollars behind it, right? So we can think of something as being a social issue, but we cannot quantify what is the effect of that. Here we can quantify the effect, and what we can see is that it makes a huge difference. So let's see how we can find a new way around this. So what are my core messages? One, we can achieve the major social objective of eliminating this discrimination easily. So it's not a big deal. We don't need to throw the baby out with the bathwater. We don't have to throw out the old methods. We just have to make a few changes. Overall, we can have a substantial change in outcome without radical changes in the methods. So that's the bottom line. We can do this. Jerome said we can do it. I'm going to show you what are the ways in which we can do this. So what's the methodological approach? By the way, I used to be a professor at one time and also recently. And so this follows that kind of thinking. And also I should say that, you know, my name is hard to pronounce. It's harder than even Kamala Harris's name. So many people just call me Prof. Even people I've worked with for several years, they find it hard to say my name. So they just say Prof, and that works fine for me. So here's the professor talking, the methodological approach. Our approach is to develop several options to replace current calculation system. Not one method, but several options. Why several options? This gives us assurance that the new law will not back us into the corner, into a corner. And we present 4 options. Other options may be possible, but these are the 4. We didn't discard any option. These are the only 4 that we could think of. Well, once you have options, you have to have some criteria by which you can judge those options. So we have also developed 5 criteria, and I'll show them to you. We have grouped we have 4 options. They are in 2 groups. And I'm presenting them in order of increasing complexity. In group 1, everybody gets the same amount. We use the same historical data as we are using now. In option 1, we gave the overall average earning capacity for everyone. So everyone gets the overall average, no discrimination in that sense. Everybody gets the same average earning. Option 2 is everybody gets the earning capacity of the highest race and gender for all plaintiffs. So everybody doesn't get the average, everybody gets the highest. And this was proposed by Robert Johnson in a paper for California. So option 2 is really his option. So everybody gets the same amount. Let's go to group 2. Group 2, we allow fair differences. What's fair? Well, that's subjective, but please look at the options that we have. Option 3, we continue to use the same data as we have been using, and then we calculate the higher of 2 earning streams. 1, what you would get if we identified you with your own race or gender group, or 2, a white men. Why white men? Because nobody says they face discrimination. If you get the same as white men, then you are not being discriminated against. So either you get yours or you get what white men get, and white men get the same, so we are all okay. There's a subtle point here. Richard showed us that Asian men actually earn more than white men. So Asian men would get what they would be in their own group. They wouldn't get what white men get. They would get what Asian men get. Option 4, use discrimination factors derived from econometric studies. There's a huge amount of economic and econometric literature on discrimination in the marketplace. And we could take that information and develop factors that vary by race and gender. So we have the 4 options here. Now let's look at how we would evaluate those. So the criteria I have presented in the order where we think that the first one is the most important and the last one is the least important. So they are in order of decreasing importance as judged by us. So first one is obviously consistent with the proposed law. And here we look at the level of consistency with the proposed law. Second, it should be consistent with standard economic and financial principles, meaning it must be sound. Number 3, it must be consistent with ongoing practice in estimation of damages, meaning we don't throw the baby out with the bathwater. We do what we have been doing to that extent. Number 4, it must be based on readily available objective data. After all, these things are going to be litigated, and so they need to be supported by data that is third-party, objective, readily available. Everybody can look at it. And finally, sort of a catch-all, have a simple, clear narrative, understandable by all participants. In other words, you should be able to explain to the jury and to the judge and to the plaintiff and everybody, this is what we are doing, so that everybody gets it. So 4 options, 5 criteria, we put them in a matrix. So the columns at the top, group 1 and group 2, option 1, option 2, option 3, option 4, and the 5 criteria. And there's a lot of information in there. I'm not going to go into the details here. And we have put in our own assessments here. Since they are our own assessments, I don't want to focus too much on the assessments, because what we are doing is we are proposing a framework, how to think about it. We are not saying this is the only understanding that we have or that everybody should follow. What we are saying is this matrix is the way to think about it. We can change the criteria, we can change the options, but this is how we should approach it. Having said that, let me look at the 1 or 2 places where we have ranked it low. So let's look at option 1. Option 1, we rank low and consistency with draft legislation. Why do we rank it low? Because it penalizes those who are above the average in the current system. The law is saying don't reduce it, but then we are reducing it for that group. So it has a low level of consistency in our opinion. And then when we look at option 4, we find that when we go down to criteria of 3, we find that we rank it low. Why? Because it's not a current practice. Looking at econometric studies and calculating some kind of an average for them is not current practice. Number 4 criteria based on readily available objective data. That's also not true for the studies because the data are all over the place. You get 5% in some case, 20% in other studies. And so it's difficult to say that there's a readily available consensus which is agreed to by most economists. We don't have that. So I rank that as low on these 2. What that means is that based on our judgment, and that's just our judgment, it's really between options 2 and option 3, though we present all 4 so that everybody can discuss for themselves and assess for themselves how to proceed. So that's it from me, Jerome.
Okay, so if we look at the 4 options, and particularly option 2 and 3, we have ways in which we can talk about meeting the legislation which says not reducing the damages based on impaired earning capacity. And Bob Johnson will talk a little bit more about what we mean by impaired earning capacity and the role of the economists in dealing with impaired or valuing impaired earning capacity. So we can reduce the adverse effects of discrimination, and this is an important goal. We laid out the some ways in which we do it. And we see this matrix in our discussion here in DC as the beginning of the discussion. And with input from various constituencies, we can talk about finalizing workable methods in order to meet the social goals. So at this point, I'll bring in Robert Johnson to talk about his experience with working in this area of impaired earning capacity. So Bob?
Thank you, Jerome, and thank you everybody for being here today. Good afternoon. My name is Robert W. Johnson. I'm a forensic economist with an MBA from Stanford University. I specialize in calculating damages in civil litigation. I've testified and qualified in over 40 states, 2 territories, and I've done several cases in the District of Columbia. I'm a founding member of the National Association of Forensic Economists. We can go to the next slide, Jerome, please. Thank you. I was the only economist to testify before the California Assembly and Senate Judiciary Committees regarding California Bill SB 41. It was passed unanimously. And I say that again, unanimously. Nobody voted against it. And it was signed by Governor Newsom on July 30th, 2019. SB 41, now codified as Civil Code Section 3361, is an important step in eliminating structural, racial, gender, and ethnic discrimination in civil damages. But my involvement did not start just last year. Over 25 years ago, I was a forensic economist in a trial regarding the wrongful death of an African-American college student in West Virginia. Next slide. My task was to calculate the future lost earnings capacity of this young man using the US government educational attainment tables. Let me set the stage. In the courthouse, the only non-white people were the decedent's parents, the 2 attorneys, and myself. During my cross-examination, I was asked if I took into consideration the socioeconomic background of the young man. I said to opposing counsel, I don't understand what you're talking about. Can you be more specific? The opposing counsel said to me, did you take into consideration the fact that he was Black? I replied, yes, I did. Then he looked at me with a lot of consternation. He said, but your numbers utilized the earnings of a white male college graduate. I said, I didn't have any choice. I turned to the jury and explained as follows. The US government educational attainment tables are the standard used and relied upon by forensic economists for establishing lifetime earnings based on your level of educational achievement. Its data collection started in 1950. It includes people, we can just go back. I'll tell you when to go to the next slide. Just stay there. Thank you. It includes earnings for people up to age 65. But at that time, if you were in your 40s, 50s, or 60s, it meant you were already in the workforce in 1950. That was before Brown versus Board of Education in 1954, before the Equal Pay Act for women. Where you finish is significantly impacted by where you start. I don't know of a single economist who will state that minorities and women were not significantly negatively impacted in hiring, pay, and promotion. The only data set that did not include any of the racial or gender bias was white males. Economists must assume that in the future, employers are going to follow the law. As I continued to talk to the jury, I said, look, we pay court reporters the same, whether they're black, white, male, or female. We pay postal workers the same, whether they're black, white, male, or female. I turned to defense counsel and said, you'd pay them the same, right? And he said, of course, of course. I said, see, I don't have a choice. I'm going to do the same and assume we're all going to be paid the same and we're going to follow the law. The jury saw through the shortchange that he was trying to pull over on them and totally rejected it. In California today, women and minorities constitute 70% of the population and over 60% of our high school and college graduates. If they get injured, they will be systematically shortchanged by devaluing their lifetime earnings in the millions of dollars. This shortchange occurs because, according to a survey by the National Association of Forensic Economists, 92% of forensic economists involved in civil litigation use gender, race, and ethnically based statistical tables. These tables preserve and reinforce workplace discrimination and fail to account for the progress we have made as a nation. Those harmed are the most vulnerable in our population, our children. Injured children who have not yet worked, who have not reached their terminal education level, or have not committed to a career path. Now, I talked about what happened 25 years ago, but this still exists today. Let me give you an example. Assume an economist has to calculate future lost lifetime earnings for 4 profoundly injured newborns, 1 male, 3 female. Assume all of the parents of these children are professionals. And according to the Census Bureau, what they designate as a professional, you either have a JD or an MD. Using the historic race and gender-based statistical tables would produce the following shortchange. Next slide, please. So what we see here is that shortchange based on race and gender compared to a male. If you were an Asian female, you would be earning, your lifetime earnings would be $1.1 million less than a male. A white female, $1.9 million less. An African-American or black female, $2.7 million less. This is starting at birth. Next slide, please. Race and gender-based earnings categories are wrong. The US government database started in 1950 and includes pre-Brown versus Board of Education and pre-equal pay racial and gender pay injustices. Next slide. No economist that I've met, and I've been doing this for over 30 years, will state that women and minorities were not negatively impacted in terms of their hiring, pay, and promotion. Next slide, please. Economists should assume that future employers will follow the law and not discriminate. Now let's talk a little bit about the specific language in Civil Code section 3361. Next slide. It says specifically, estimations, measures, or calculations of past, present, or future damages for lost or impaired earnings capacity. Next slide, please. Resulting from personal injury or wrongful death shall not be reduced based on race, ethnicity, or gender. As an economist, now I got a rule to work with. But also as an economist, I've got to figure out, how do I apply that rule? How do we go from words to dollars? Well, for the last 25 years, our organization has used the following methodology. Next slide, please. We call it the capacity selection methodology. It consists basically of 3 basic steps. Next slide. the first step is determine that you are calculating capacity. Now, this seems obvious, but it's important because there's a difference between past lost earnings and lost earnings capacity on that part. So we need a specific definition of capacity. As a forensic economist, where do I go to get my definitions? Next slide, please. Jury instructions. Jury instructions are critical to us in the forensic economics field. They give us sort of our left field and right field foul line. Stay inside this, you're okay. They usually tell us, okay, this is what you got to include in the calculation. There's stuff you don't include. Doesn't tell us how to do the arithmetic, but it says this is in, that is out. So, and we go to jury instructions for our definition. Next slide. So in California, it's CACI, for somehow they call it KC, 3903D on economic damages, lost or impaired earnings capacity. Next slide. And what it says is essentially, it is what the plaintiff could have earned. Now, it's really important to separate that from the word would, because a lot of people say, well, what would they have made? No, it's what could they have made. I've got a 4-ounce cup here, and I just drank the little bit of water that I had in it. And so what I just did, I just destroyed the capacity of this cup. It doesn't matter whether I only had 2 ounces in it or 3 ounces in it, or the average amount that was put in it was 3.7 ounces. I took away its capacity. And so what we found is that is the framework when we use the word capacity, what was taken away. Next slide, please. Step number 2, there's a select the level of educational attainment. Now, this is a level, a figure that is usually given to the economist as an assumption. I, as an economist, I don't pick the level of educational attainment as an expert opinion. That's an assumption given to me either by my retaining counsel or there's another expert who lays the foundation. Next slide. So when we go to the educational attainment tables in the US government databases, they go all the way, the most predominantly used ones are high school grad, and that includes even the GED. You got some college, no degree, an associate's degree, which is 2 years, bachelor's 4, master's degree, professional, and a doctorate. The Census Bureau has calculated many different earnings levels in continuing less than a high school grad. The third and final step is, next slide, please. Select the highest median earnings regardless of race, gender, or ethnicity. We use the measurement term median to satisfy what we call a test of reasonableness. Median means it's right in the middle. 50% of the numbers are above this, 50% of the numbers are below this. It is right in the middle. No bias up, no bias down. Next slide, please. So there are many tables in the educational attainment reports as published by the Census Bureau. How many? Let's go to the next slide. There's over 400. So I only have a couple of minutes left, so we're not going to go through the whole 400. So what I did was I put together a table just for a person with an associate's degree by the different categories of race and gender in the top ones that we traditionally look at. We can have the next slide. And as you can see, it goes from the top category for an associate's degree is the annual median earnings, $59,049, and that's from ages 25 through 64, up to the 65th birthday, in fact. That's what it exactly means. And that, in this category, it is white male is the top race, and gender on that part. It will not be that for all the categories, but just for this category, that's exactly what it is. And you can see as you go through the chart that below that you have all males, then you have Asian males, Black males, Hispanic. When you combine all races and all genders, that's even below that. And then you get into the female categories, again, bottoming out with African-American females. It will change as you go from category of educational attainment to category of educational attainment. Now, I put together another chart for a person with a professional degree because that's who my audience is. So I thought I'd make this personal. Next slide, please. As we can see, for the professional degree, JD or MD, what tops out is and my data set is the 2018 educational attainment tables. So my numbers will be a little bit different from the ones that the page group put together. These numbers top out at 150,000 for Asian male, then you've got white male, then you've got all males, Asian female, and then it continues on down. And finally, I compiled a table that is 3361 compliant for all levels of educational attainment from high school grad. What happened? Did I lose power?
We can still hear you and see you.
Okay, from high school grad to doctorate. So I had my screen went blank. Are the screens being projected there still?
We're still good.
Okay, fine. So you guys keep talking. I'll just deal with this. So as you can see, the 3361 compliant table, we have the median earnings for high school grad at 46,000, some college 52, associates 59, bachelor's 82, master's 102, professional 150, and doctorate, which is other than JD, MD, 117. So these are the tables that we have been utilizing. Just as a segue into a sort of boots on the ground experience, I have not had any issues over the past quarter century presenting these numbers. And when I say I have not had any issues, in California, we're allowed to have the jury ask questions of the witnesses. Never had a question on this. When they questioned the jury's post-verdict, there was never any question about the inappropriateness of these numbers or this methodology. I've never had an opposing counsel say, stop, sidebar. Never happened on this. It's never coming up on any cases that have come up on appeal on that part. So we have had no issues on that part. I will tell you though, for the economist on the other side, it has not been a pleasant experience in terms of why are they paying them less based on either race or gender. So I want to thank you for your time. If I can go to my last slide, that has my little logo on it. And I turn it back to you, Jerome.
Okay. So it's on to you, Chris. Thank you, Bob. Very nice.
Thank you all. This was fantastic. The data is really compelling to look at. I thought it was worth noting, and John Lopata, one of our members, sent me an article or a complaint yesterday, and it's worth noting that there was recently a lawsuit filed against the NFL, which is similar, touches on similar issues, I think. The issue in this case, it deals with the concussion and all the litigation and the class settlement involving the concussion situation in the NFL. And it was noted that race-based benchmarks were being used in the awarding of benefits through that program. And I thought it was timely for our panel today because of the similarities in how race-based statistics were being used, and it was causing many African-American players to be denied benefits, whereas white players would receive the benefits in that case. So if you're interested in that, there's a New York Times article today about it. Thanks to John for sending it over. I thought it was, it's fascinating and discouraging at the same time to read about how we're still seeing, I think, Robert, I think you used the term, these baked in discriminatory practices into data. I just want to comment briefly, and then I know that Mary put in that if anybody has questions, to please put them into the chat box, and we'll be happy to raise them and address your questions. But as a practitioner, you know, I think the first thing that we have to deal with, and this is before we have legislation that is controlling, of course, is we need to make sure that our reports are admissible. You can, as the lawyer representing a victim, we want to do the right thing, certainly, but we also want to make sure that we can get our reports in evidence. There are some judges who I would be concerned that if we ignored gender and race, would have concerns about our reports. I thought that the presentation today was great on helping us to bulletproof those reports in that way, as far as how to make sure that they are going to be admissible and how we can establish that the methodology was proper. But we do need to think about that. And I think, you know, for me, if I was really concerned, I think one course of action is to give a range, provide a range and provide all the tables. It certainly puts you as the plaintiff's lawyer, I think, in a better position in front of a jury to suggest that the jury should not consider race, and then put the defense lawyer in the spot where he or she has to stand up and say, oh no, you should discount this because somebody's black or because someone's a woman. I'll take that argument to a jury every day and trust that they'll do the right thing. But we also have to, of course, deal with judges and the admissibility of our reports. So that was one thing that I thought was worth raising. And then along those points, I think it's important in our direct examination of our economist experts, of our forensic economist experts, that we really elicit what the data, where the data comes from, and explain to a jury what the historical data is that economists rely on in creating their loss reports, while explaining, you know, that this data does include our kind of ugly national history of systematic racism. And that is important to raise if you are going to have an issue of if the reports and the numbers are being used with reasonable methodology by the economists to create them. I mean, you probably need to explain to a jury why a male's numbers are being used, historical numbers are being used when the victim is a woman. I just wouldn't take it for granted, but I think that there's enough data, and certainly the experts we have on this panel today can do an incredible job explaining to the jury why the data is flawed and is not necessarily the best way of presenting future-looking evaluations and reports. I don't really have anything more that I want to add at this point. I think there's probably some questions. Mary, are you going to handle the questions?
Sure. They're right there in the Q&A. Can everybody hear me okay? Mr. Johnson, you have a question from George Tolley. The question is, if you have been able to present the Section 3361 compliant earning capacity numbers for about 25 years, why was a change in the law necessary?
Because I don't do all the trials in California. So if I'm doing all the trials, it comes in every trial. But I'm not doing all the trials in California on that part. So it's not like I'm going to be there in every trial. I think it's something that needs to be structurally dealt with, because it's not just my testimony, It is an economic fact for the benefit of all.
Great. Okay, thank you. Now let's see, we have another question from Joe Rosenberg. The work-life expectancies, or WLE, of women are typically shorter, most specifically due to differences in time out of the labor force for childbearing and child rearing. By using gender-neutral WLE, aren't we, one, disadvantaging men with shorter WLE than is more probable than not, and two, ignoring biological and empirical differences that, while being lesser today than before, still do exist?
Okay, I'll take Joe's question. Joe's a colleague. He's also a member of the National Association of Forensic Economists. So how you doing, Joe? So it's a good question. So for the audience, what do we mean by work-life expectancy? So let me just give a brief introduction to what that is. So let's say that you start working at age 20 and you stop working at age 60. Or let's say you're in the labor market from age 20 to age 60. But you don't work you may not work all those years. You may take time off to go to school. You may take time, in the case of female, may take time off to give birth to a child, or men and women to help raise a family. If you're on a college campus, you may be on sabbatical. So there are a lot of reasons that while you're in the labor market for 40 years, you're actually working less than that. So the work-life expectancy gives you that number of the time that you're in the labor market. And so what Joe is saying is that given that time in and out of the labor market, will we be disadvantaging men? And the answer is no, because the legislation says you cannot reduce based on the tables. So if the tables give you a higher number, and this is something that Bob alluded to and Subodh alluded to, then you can go with the tables. So I don't think it doesn't say you must use race neutral tables in this case when it comes to work-life expectancy. And then ignoring biological and empirical differences than white being lesser today than before still do exist. Well, that takes us into I think what you have to get is a medical expert to testify that somehow because of biological differences, their work-life expectancy would going to be different. That wouldn't be something I would touch as an economist to try to tease out the biological differences.
Hi, this is Bob Johnson. May I add a little something to that?
Sure.
Thank you, Jerome. I think as a forensic economist, let me just say primarily a couple of things. Number one, in the analysis that I did today, I didn't do any work-life capacity or work-life expectancy. I was talking about what is the loss of the capacity to work from the dollar value from ages 25 through 64. So that's just that straight time period. Also, so there's no work-life adjustment, male or female. I would also state that going back to the jury instructions as my bodyguard, as my telling me what I need to calculate, it's like with the cup. If the injury took away their capacity, the capacity to work was up to a specific time period. Whether you were in the labor force or out of the labor force is immaterial. The destruction is of the capacity, like the cup on that part. I think when you start to get into biological this and other areas, now you're getting into some areas of, I would say, would be forward assessing historic issues of gender bias on that part. And so I look at the capacity as strictly based on what the law says, lost earning capacity, not lost average earnings. Thank you.
Well, Bob, just as a follow-up to you,
Sure.
when you're measuring capacity by educational level, are there other ways to measure capacity?
You know, there may be other ways to measure capacity by educational level. So I'm only talking about the area in which you're going to utilize a U.S. government table. If you're going to measure earnings capacity by a different metric, I think you need to bring that metric forward and show that that specific metric is not one that has historic racial or gender bias baked into the numbers on that part.
Right. So
But most of the cases that I wind up doing are profoundly injured children's or young adults. So I'm not saying this methodology that I have needs to be applied in every single case, because if somebody already has a work history and they've already committed to a career, obviously you would use that. On the other hand, for the children and those who haven't, or those in their early 20s, I think this is applicable.
Okay, thank you. Mary, you have another question?
Sorry, yep, here I am. And I noticed there's also some questions in the chat box. So try everybody to put your questions in the Q&A box, or else it gets confusing. Okay, so the next question in the Q&A box is from Robert Fitzpatrick. The question is, if the court rejects a non-discriminatory methodology, how do you fall back to an alternative, and what alternative?
I'm not
Well,
sure.
I can respond a little bit.
Sure.
I can respond to that. I mean, this is one of the things where I think trial lawyers are paranoid often about what could go wrong and how does it go wrong. That's why I suggested using a range and having the forensic economist report include the different ranges of earnings. If you're really concerned that the judge or the court is going to reject a non-discriminatory report, then prepare the discriminatory table and have it there available, so that if you are in court in front of the jury and there's an objection, or that there's a hearing prior to your trial and your report is thrown out, at least only part of it is held inadmissible, you can then fall back on what we can deem a discriminatory report, and you can fight the battle at the next level if you have to. But again, keeping in mind that you want to make sure you can get your evidence in front of the jury and in evidence at your trial, you may be best served by preparing the range of earning capacity loss, so that if you get a bad ruling, you're not down to zero and you don't have your whole report thrown out, you have a portion of it thrown out. That would be my recommendation. And if there's anybody, I know there's some very experienced, savvy attorneys on this webinar right now. If you have other ideas on that, I think we'd all love to hear them.
Well, I would add, I can't speak as an attorney, but in getting our paper reviewed before we present it in the conference in February, one of the lawyers that reviewed the paper practiced in civil rights and equal protection law. And the claim that the questioner put forward, they would argue was not they could not raise that claim under equal protection factor. In other words, if a defense, it's incumbent upon a defense to establish that there's other data available. It doesn't fall to the plaintiff to do it, because you have, under the equal protection action, you have to use whatever readily available data is there. Otherwise, you cannot claim that it's going to harm you as a defendant. So we lay that out. We lay that article out, and that argument out in the paper that we presented, and we can make that paper available to folks as well.
Okay, I'm going to ask, there's another question here from Chris Figueres, who is our legislative director. She asks, how does life expectancy play into this discussion? Certain genders and races statistically live longer. How does that affect earning capacity? And then how did the change in the California law affect cases pending at the time the law became effective? So, two-part question.
You want to take the first? You want to take those, Bob?
Okay, fine. Let me take them in reverse order. What has happened in California since January 1, 2020? I have not heard of, and I've been checking religiously, of any cases whereby the economists who may have done their report the old way were not permitted to update their reports if they so chose to comply with SB 41 in their opinion. So I've not heard through that. Now, there haven't been a lot of cases because the California court system, particularly since the middle of March, has been effectively shut down. I think I've done two Zoom trials myself in California, and none of them had to do with earnings capacity for somebody where we would have used those tables. But I haven't heard anything from January 1 through the middle of March where any economist was prohibited from providing an amended report if they so chose to handle the change in the law. Could you repeat the first question again, first part of the question, please?
Sure. How does life expectancy play into this discussion? Certain genders and races statistically live longer. How does that affect earning capacity?
Well, I'm not aware, and maybe Jerome can correct me. Most economists don't calculate lost earnings capacity out to the end of a person's life expectancy. They usually stop short of that. They'll usually do when they can first get Social Security, or they'll use one of the work-life tables. But I'm not aware, I don't think I've ever in my 35 plus years calculated it out to the end of a person's life expectancy for earnings. And that's why it talks about in the California law, the aspect of earnings, not all damages. So it's nothing to do with what we would call a future medical expenses or life care plan expenses.
So let me respond to that. Yes. So we economists have to determine a point at which people separate from the labor market. So it'd be more of a work-life expectancy question, or a separation from workforce and from the labor market. So to the extent that one use tables to do that, there could be some biases, because there are some studies that talk about when do people separate from the labor market. And there are some biases for that. For those who are self-employed professionals, the data says we never separate. We just keep working and working and working. So I don't know whether that's good news or bad. Now, on the other point, there in the literature, there is a method to take it out to life expectancy, and it's called the LPE method, but very few economists use it. So you take a combination of the probability of a person being alive, the probability of a person being participating in the labor market, and the probability of the person being employed. And you take that all the way out to, you just take the life expectancy tables and you take it out to 100, 101. But as you get further out, the probability is so low that the dollar amounts are minuscule, if at all.
Okay, great. And I'm just trying to be respectful of everybody's time. I'm going to put in one more question that I see here at the end of the chat, and we'll just end it after that. So the question is DC an earning capacity jurisdiction? Maryland and Virginia are, but is DC about expected earnings?
I'm not quite sure how to interpret that question. So yeah, I think it depends on the case. There's a lost earnings, which we haven't been talking about, lost earnings, which would be an expected value. And then there's lost earning capacity. And as the examples that Bob used, is let's take the example of a child who doesn't have an established earnings history. How do you measure their lost earning capacity? And
Yeah,
go ahead.
yeah, I think what I've done in the cases that I've testified in DC, my remembrance of the code or the jury instruction is the word capacity is in there. There is also a separate section that talks about lost earnings, which is why I said the first step in my methodology is determine that you're calculating lost earnings capacity. That is a measure of what your code or your jury instruction says. So that's not an economic issue, that's a legal issue. So if the word capacity is in there that you can claim, then you're doing capacity. If it's lost wages, then you're doing something else.
it. Okay, great.
You look
Go ahead, Jerome. Did you have something else to say?
Chris, you looked a little quizzical. Did you have something to say?
No, nope. I was just trying to remember that I always tell people that the trouble of multi-jurisdictional practice in DC, Maryland, and West Virginia is that every time I get a question like that, I always have to look back at the instructions and remind myself, because I'm never comfortable just coming off the cuff because we practice in so many different areas with different laws on it. So, but I appreciated the answer.
Thanks. Okay, Mary.
Okay, well, I thought this has been a wonderful program. I have recorded it, so we'll be able to share it with our members. And if anybody, any of the speakers want a copy, I will certainly make it available to you. I know there were questions about the materials, and I believe, Jerome, you shared your materials. I don't know, Robert, if you were sharing yours as well, if yours were in there as well, just to let
They were.
They were, yes. Okay, perfect. So we have everything shared. We have it recorded. We thank the panel for their time. It was so instructive. And I thank Chris for moderating it. And with that, I shall say goodbye and have a wonderful day. Everybody stay safe and healthy. Thank you.
Stay safe, everybody. Thank you.
Bye, friends.